The topic today, hot topics at the High Court. We're very fortunate to have Leslie Gilo-Jacobs, who is the Justice Anthony M. Kennedy Professor of Law and Director of the Capitol Center for Law and Policy at McGeorge School of Law. She served as a law clerk to Supreme Court Justice Lewis F. Powell, Jr. Her specialties are constitutional law, lawmaking, government structure, Supreme Court operations, and free speech. Professor Jacobs has been with us in the past to discuss cases before the Supreme Court. She's here again today and near the end of this year's Supreme Court term to discuss the hot topics on the court's docket, the changed composition of the court, and trends in the decision making. Before we begin, I do have some announcements to make to you today. First, as always, our presentation is being recorded and can be accessed by going to the Renaissance Society Forum channel on YouTube. Now, during the presentation, if you have a question, go to the Q&A icon at the bottom of the screen and enter the question in the text box. It will be addressed at the end of the presentation. However, please note, as always, that the chat function has been disabled. Also, you may disable or enable closed captioning by going to the live transcript icon at the bottom of the screen, where you can also, if you'd like, adjust the size of the subtitles. Once again, our guest today, and we're very fortunate to have Professor Leslie Gilo-Jacobs. Her topics today is going to be hot topics at the Supreme Court. And welcome.
Thank you so much. It is so good to be here again. I wish I could say that I can see you all, but I can't, but I know you're there. Zoom has its positives and negatives, as I'm sure you've learned during this whole pandemic. One of the negatives, of course, is that we're not in person like we were before. But maybe one of the positives is that more of you have found yourselves able to show up. So anyway, welcome. I'm so happy to be here. And as Bob was saying, it's perfect timing. We are nearing the end of the Supreme Court term. And as he said, I'm going to be talking about hot topics at the High Court. So I'm going to be talking about the topics. We'll talk about the Affordable Care Act, religion, voting, speech, guns, abortion, affirmative action. But before we do that, I thought I would cover a little bit of background because we're talking about the Supreme Court. And of course, you all know what that is. And you know it's got 9 members on it. It hasn't always had 9 members. Congress is the one that decides how big the Supreme Court is, but it's been 9 members for quite a while now. The Supreme Court, again, some of this is just basics as we get into it, is branch number 3. The Constitution itself, Article 1, Congress, Article 2, the President, Article 3, the Supreme Court. And so the Supreme Court sits on top of all the lower federal courts and state Supreme Courts. It chooses what cases it takes. The justices meet in a conference to make those decisions. It takes 4 votes for the court to choose to take a case, and 5 votes for a majority. So it's not a for sure thing when the court, as we say, grants a petition to hear a case, what the result will be. But 4 justices might well have an idea where they want it to go. The court takes about 100 cases per year. And what kind of cases does it take? It takes cases when the lower courts have split, meaning reached different decisions. One of the Supreme Court's jobs is to be a harmonizer. But it also takes court cases involving federal questions, either statutes or the Constitution, that it thinks are important for one reason or another. And another thing to recognize with these cases is that it takes years to get to the Supreme Court. A case starts in the district court. If we're talking about the federal courts, that could take a year or 2. It goes up to the Court of Appeals, That could take a year or two. And then, as we talked about, the parties have to file a petition with the court and say, please take this case. Here are all our reasons. And then the court has to decide to do it. And more often than not, it schedules the case for the next term. So by the time we see cases at the court, they've been working their way up. And also, it's no coincidence what the court hears. Again, the justices make the choices about what to hear, but parties understand how to appeal to the justices. And so often they're framing cases early on, even in the litigation, to work their way up and become a question that the parties want the court to decide to answer. Court composition. We have the most conservative court since before the New Deal. That's since before the 1930s. Okay, the court's composition has been moving more conservative during my entire professional life. As was said in the intro, I served as a law clerk to Justice Lewis F. Powell Jr. in his last term on the court. I'll give away my age if I tell you, but it was a 1986 term, ending in 1987. And he was replaced by Justice Kennedy, who was more conservative than he was. But Justice Kennedy was, centrist compared to the current 6-court majority. So the last president, as we know, got 3 appointments to the court by operation of law and by Senate procedures. And so we now have 6 justices with really quite similar ways of interpreting the meaning of the Constitution and other laws. So the cases they'll decide to take and the results they'll reach are more predictable than it used to be. Let me take a moment too to talk about these labels, conservative and liberal. I always run a risk when I use them. They're blunt labels, but they're useful. But I don't want to give the idea that we're just talking about politics here. That is, we're talking about judges, right? And judges aren't politicians. They're just supposed to read the law and say what it means, right? Well, yes and no. And so let's talk for a moment, again, before we get to the topics, about the process of interpreting the law that the justices do and all judges do, and what we then mean by conservative or liberal justices. Judges, by the Constitution, as we know, get life tenure. Okay, that's a decision that the framers of the Constitution made, and it's a different decision than most states make. Right? Almost states have judges that are elected in one way or another. The framers of our Constitution federally said, no, we want those judges to be insulated from politics. And they're supposed to be doing something different than politicians. Interpreting the law, as we know, written by someone else. So either the Constitution or laws. And so there have been thoughts that there's some agreed upon way to read the meaning of the law and apply it to particular circumstances, which is what judges do. And I'm going to say that frequently there is. Okay, every year, up to 50% of the cases that the court decides are unanimous or almost unanimous. Okay, so there are boundaries on legal interpretations, and judges agree to those and follow them. So, if a law says no vehicles in the park, the judges will agree it doesn't, vehicle doesn't mean a stalk of broccoli. But does vehicle mean a tricycle? Does it mean a statue of an army tank? That's where interpretation is required. Or let's take an example from the Constitution. The Constitution, all it says is Congress shall make no law abridging the freedom of speech. Well, is cake baking speech? Now, you might listen to that first and say, well, that sounds like a stalk of broccoli, right? But I believe at this point in time, we have at least 5 justices on the court who would say that cake baking is speech, at least in certain circumstances. Okay, and they're not getting there by reading the words, freedom of speech, or even by looking at what the framers of the Constitution in 1789 were thinking about, because I think all the justices would agree they weren't thinking about cake baking. They're using a bunch of different tools of interpretation to get there. And so my point is that in the center, right? Interpretation of words applied to new circumstances is inexact, inevitably inexact. And no one has a lock upon the agreed upon correct way to do it. So, for example, Chief Justice Roberts, when he was getting confirmed, said, oh, I'm just calling balls and strikes. And our most recent justice, in her statement, said, oh, I'm going to leave policymaking to the legislatures. And again, it sounds like the right thing to do. But I just want to say, as far as interpretation goes in those middle ground cases, it's just can't be true. This newest justice has been the key vote, as I'll talk about later, striking down, California's COVID restrictions in a number of cases, in New York's as well. And these are restrictions imposed by a governor who represents tens of millions, right, of citizens. So the result, strike it down, may seem right or wrong to you, but it's not leaving policymaking to the legislature or to the elected branches. It's exercising judicial power to strike down the policy decisions of elected officials. And I'm saying conservative justices do it, liberal justices do it when they have the power to do it and when they think it's appropriate. So to repeat, interpretation has some constraints, but in that range of close politically controversial cases, so-called conservative and so-called liberal justices, again, blunt generalizations, come to the job of interpreting what the law means with predictably different experience and perspectives that lead to predictably different results. And that's just the way it is. But the other thing I want to say is true. And I clerked for a Supreme Court justice and I respected him enormously. And actually I clerked for a judge. I should mention this. I clerked for a judge who was appointed by a president from one political party, a justice who was appointed by a president from another political party. I respected them both enormously, worked for them, wrote their opinions, and knew they were trying to do the very best job they could. And that's what I think about the justices on the Supreme Court, that every single one of them thinks that they are doing absolutely the right thing when they're interpreting and deciding cases. So my point isn't to be cynical here, but I do want to say judging isn't science. It's not done by computers, it's done by human beings. And they're put in place through a political system and they're operating within it. So who the human beings are who interpret the law is extraordinarily important to what the law means. And it's important to the healthy functioning of our democracy that we all understand that. Okay, so on to the cases. What's happening? Obviously, I can't cover everything. So what I've tried to do is pick out the cases that the most of you would find the most interesting. Starting out with the Affordable Care Act. Okay, this was a while ago that it was argued before the Supreme Court. The case is called Texas versus California. Texas brought the case, California came in to help defend the Affordable Care Act. And this is part of the continuing Affordable Care Act saga. Okay, it's been going on for over a decade. As we know, it was passed with what is called an individual mandate. And that's the requirement that people purchase insurance. Okay, that was part of the whole jigsaw puzzle of making the Affordable Care Act work the way Congress wanted it to. It got challenged and got upheld ultimately in a close decision with Justice Roberts crossing over and voting with the more liberal justices to say that it was a constitutional tax. Okay, but and in 2017, we've got a different Congress and it took that penalty down to 0. Okay, so Texas and other states brought a lawsuit and said, well, now that that tax is down to 0, it can't be a tax, right? Because it's not making any money at all. And took it before a district court. That's where it started. And the district court judge said, well, yeah, you're correct about that. Okay, so Congress doesn't have the power to pass the individual mandate. Oh, and by the way, every single part of the law hinges on the individual mandate, so the whole law is invalid. Okay, so that went up on appeal, and ultimately the Supreme Court decided to decide that. Okay, so what we need to understand is the Supreme Court's not deciding the same case that was there 10 years ago, right? It already did that. And that original case was dramatic, okay? But I want to say that this one's probably less so. That is that the real issue in this case, it has to do with whether that individual mandate provision can be cut off from the rest of the law. They call it severing. And if it can, then that's probably the result the justices will reach, as opposed to striking the whole Affordable Care Act down. And why do I predict the justices are going to reach that result? It's because this whole issue of lopping off parts of statutes or severing parts applies to lots of different statutes besides this politically charged Affordable Care Act. And so it seems from oral argument, and it just seems looking at the issue, that we'll probably see the court do something less dramatic than strike down the whole Affordable Care Act. And as a matter of fact, it could possibly dismiss the case on the technicality that Texas can't even bring the case at all. We'll see. Next topic, religion, religious liberty. Okay, that has been the location of lots of movement in the law, both over the past number of decades, but also in the past number of years and in this particular year. Okay, there are two clauses in the Constitution, as you know, that have to do with religion. One of them says government can't establish a religion. That means it can't help religion too much. And the other clause says government can't prohibit the free exercise of religion, meaning it can't hurt religion too much. So, Scylla and Charybdis, right in the middle there, is where governments are allowed to do things. And it's the court's job to say, have you gone too far this way? Or have you gone too far that way? Okay, and so I've been saying that, I said that there's been movement in the law as far as both clauses and religious liberty in general. And so it's over the past couple of decades that the court has contracted the scope of the Establishment Clause, meaning it has held that government can give more types of aid to religion, okay? More money to religious entities and to religious schools, and can associate itself with religious symbols more. Over the last few years, the court has been working more with the Free Exercise Clause, and the court has been expanding that as well, and has expanded that to say that not only can the governments, states and cities, give money to religious entities, but as a matter of fact, in lots of circumstances, the government must give money to religious entities if the government gives money to non-religious entities that do the same kind of job. Okay, so like schooling, religious private schools, if you give money to private schools, then you have to give them to private religious schools as well. If you're giving money for a recycling program, using old tires, and you're giving it to anybody who wants to do that, well, if a church wants to recycle with old tires, you must give the money to them too. So what we have before the court right now, we have another case that has to do with how much that Free Exercise Clause, the religious liberty guarantee, requires a government, and here we've got the city of Philadelphia, to fund religious entities. And so this has to do with contracting. It's a city of Philadelphia, and it contracts with a number of nonprofits to make foster child placements. Okay, and one of those nonprofits for a long time has been Catholic Social Services. Okay, but it came to the attention of the city of Philadelphia that Catholic Social Services would not place foster children with gay couples, and that violates the city's non-discrimination policy, which says no discrimination on the basis of sexual orientation. So the city of Philadelphia said, we're not going to provide you money anymore because you're violating our anti-discrimination policy. Okay, so this is an interesting case because it shows a situation that is going to happen all the time with individual rights guarantees generally, and it happens with this religious liberty guarantee, right? Which is, the Constitution says religious liberty, you've got it as an individual, but the Constitution also says democracy and states' rights, you, the state government or city government, can enact the policies that you want to enact and enforce them. Okay, and so here the city of Philadelphia says no discrimination on the basis of sexual orientation. The church says religious liberty, it violates our religious liberty. It's a conflict between those two things. And so that's what the court has to decide and has been deciding. So what will the court do? Who knows for sure, of course, but it looks like Catholic Social Services will probably win this one. That is the direction the court has been going with religious liberty. But it is possible that Catholic Social Services will win on a more narrow ground. That is, a broad ground would say, we interpret the Constitution, states and cities, so that when you contract, when you give out contracts, right, you must give contracts to entities that engage in activities that violate your civil rights laws, right, if they assert religious liberty. That would be a broad holding, and it would apply all over to all sorts of cities and states, including California. A more narrow holding, which looks like it might be more likely, is that the justices may say, we look at the facts of this particular case, and it looks to us like you, City of Philadelphia, acted with hostility towards Catholic Social Services on the basis of their religious beliefs. Okay, and it would still be the same result. CSS wins, but it wouldn't apply as broadly. It would just apply to this case. We shall see. Religion. This one was viewed as the big religious liberty decision, but you know what? The court stole its own thunder. And it stole its own thunder through the emergency orders that it's been issuing with respect to COVID. Okay, and again, these things are making the news. You've likely seen them. Two of them had to do with California, right? Twice the justices have, slapped at California, invalidating COVID restrictions on religious worship. One of them having to do with in-home worship, and one of them having to do with in-institution worship. This is dramatic, what's going on with religious liberty, and it's dramatic in a number of ways. Number one, it's dramatic as to result. It's an expansion of the religious liberty right under the Constitution. That is, it seems that the rule now is that states can't impose restrictions on religious worship if they allow other activities, that the justices view as similar to religious worship to operate without the same level of restriction. Okay, so for example, religious worship versus grocery stores or movie theaters. Okay, and so that's a change in the law, and it gives more religious liberty right. These cases have also been dramatic for their procedure. Okay, that is, the court, 5 justices at least, are stepping in on these emergency orders. Right. And it used to be that emergency orders were rare, and they still are. And what's rare about them, and rare for the court to do something, is that there hasn't been a full hearing. Right. As I told you, these cases often work their way up to the Supreme Court over years and years and years. Right. So the district court takes evidence, there are transcripts, there's all sorts of things. And there's at least hearing an argument before the Supreme Court. But not so with these emergency orders. Okay. It's possible to come in on a Friday and get a ruling Saturday afternoon. Okay, that can happen in the lower courts, but it's happening more and more at the Supreme Court over the past several years, and it is happening with these COVID orders. Okay, so it's extraordinary and dramatic that the court is second guessing the judgments of governors on such an emergency basis. Okay, and it's also dramatic, these orders, because they show what a difference the justices on the Supreme Court make. Okay, you may recall, and it was in the news as well, that is some of these cases, including one from California, came up this summer. Okay, and Justice Roberts, our Chief Justice, actually voted with the more liberal justices to say no emergency order. Okay, and who knows what he thought on the religious liberty front, but his point was this is an emergency order. And usually what we do is we wait and we have a full hearing. And so I'm not going to rule in favor. I'm going to what we call defer to the California governor and wait it out, especially since these are changing. And so we see a change with the newest justice on the Supreme Court. There are now 5 justices who are willing to strike these things down on emergency orders, with Justice Roberts now dissenting. Okay, and so when he was in the middle, he was more likely to put a brake on quick movements, but he's not able to do that anymore. And this is an example, the religious liberty emergency orders. Voting restrictions. Okay, boy, these are hot topics, and they're hot topics. You might have read in the news yesterday that Florida the legislature just passed a boatload of them that the Florida governor is expected to sign. Okay, the voting restrictions that are before the Supreme Court are ones out of Arizona. These particular ones forbid third-party ballot collecting, and they require election officials to discard ballots if they're cast in the wrong precinct. So voting restrictions are a big deal because they involve the procedures of democracy, right? The result is, changes according to who gets to vote for it. And so even before the last election, because these are coming out of 2016, but now certainly after the last election, it is an acknowledged strategy that's happening across Republican-dominated states to pass restrictions on voting eligibility. And so we're going to see others of them crop up, eliminating early voting, Sunday voting, who can get absentee ballots, cutting the hours of voting on election day. And so it's going to be up to the court, and here it is with this case, to decide whether the Constitution sets any limit on the ability of the states to do these things. Okay, and the thing to know as background is that the Constitution gives states lots of power over who votes and how they vote. Okay, it's written into the Constitution, it's definitely there. And so what restriction is possibly there on what the courts do? Well, it's other parts of the Constitution, or also the Voting Rights Act. Okay, the court has invalidated an important part of the Voting Rights Act, but another part still remains, which says that states can't make changes to voting that deny a racial or language minority an equal opportunity to participate in the political process. All right, so there we've got words again, right? That are going to require interpretation in the context, right, of particular voting restrictions and particular histories of them being passed. Because, well, when is the result to deny an equal opportunity to participate in the political process? How much proof's required? What does the proof have to show? Right, it's focused on race and language minority, but we'll have to see. And it does look from oral argument that this case, that the majority of the justices are inclined to uphold these restrictions. Okay, and so the significance of that is I'll be upholding them for Arizona, but as I said, it'll send a message to other states as well about the degree to which the justices are going to look carefully at these voting restrictions. Another one that was just in the news, student speech, the cheerleader who went on the Snapchat rant using the F word a number of times, actually in her, within her private group, but somebody else found it and showed it to the school administration. And she got disqualified from cheerleading for a year. Okay, so that's been watched, and the thought is that this would possibly lead to a big decision about the scope of school authority over student speech. Okay, and schools have more authority over student speech than, for example, the government has over our speech. Okay, and that's because they're educated. The government's an educator there. Students are required to attend, and so the schools can keep order, controlling the student speech. But enter social media, and the question is, well, gosh, the rules used to apply when you were on campus. Okay, and so you could have this easy on-campus, off-campus. But now with social media, it's ubiquitous, right? People are on their cell phones, even though they're not supposed to at school. They're on their cell phones out of school, but they're talking about school to school people. And so this was possibly going to cue up a question of how to deal with social media with schools. Maybe it still has, but it looks like a majority of the justices may once again be wanting to go narrowly on this one because it looks like a majority of them on both sides of the aisle think that a year of punishment for one little Snapchat was a bit severe. So it's possible, once again, that they may reach a decision that has to do only with what this one school did, as opposed to changing what the rules are for all the schools across the country. Speech donor disclosure, that's another case. I mentioned this in particular because it has to do with California. And California has a rule that says that nonprofits must present a copy of their tax return with the IRS to show their major donors. Okay, and so a couple of conservative nonprofits have brought a lawsuit saying that that law violates their right to association. Okay, the Constitution doesn't say anything about association, but it's been read by the justices into the right to free speech. Okay, so it does exist, and the court has held that there are rights to association and there are rights to keep your members private in some circumstances. And so the question is, are these the circumstances? California argues that it's got good reasons. It's trying to prevent fraud. The nonprofits argue that it will subject them to threats and harassment. And people look at this and say, well, this is a nonprofit law, but it could possibly have ramifications for example, election disclosure laws. That's about all that's left that states and the federal government can do with respect to regulating elections, is to require disclosure, transparency. Okay, so we'll see what we get here. Not clear exactly how the court will rule. It did look at oral argument like a majority of the justices will have these challengers win. Whether it goes broad and strikes down the whole law, not entirely clear. Property rights and unions, again, having to do with California. This is was in the news and has to do with a law that's over 50 years old that allows union organizers to enter onto the property of agricultural businesses to talk to their employees about union organizing and joining the union. Okay, decision in this case, it requires an intersection of taking law. There's a part of the Constitution that says the government can't take private property without giving money for it. And then also, the authority here of California, a democracy, to make the policy choice to help unions. Okay, and so, where's the intersection of these two things? What's the court going to do on this? Again, the thought was that perhaps the court would make new law with respect to private property and say there are broader private property rights to exclude, in particular, union organizers, but maybe everyone, like inspectors who are coming on, the property state inspectors. But again, it looks like the court probably won't do that. It looks like a majority of the justices think even under the rules that exist now, this particular employer should win. And the rule right now says that for the union's organizers to be able to go on the property, the employees must be otherwise unreachable. Okay, cell phones make a difference with that, but so does also the fact that fewer employees are now living on the property of the employer. So put those things together, and again, it looks like the employers will likely win this case, but again, a narrow result rather than likely a broad one. Okay, I'm going to move on and talk a little bit about what the cases that will be decided next term or may be decided next term. And I told you that the court, the way it decides what to take is it has these petitions that the parties write and say, please, please, please take this. And then the court holds conferences and issues orders and says, we'll take this, this, and this. Okay, and so one petition the court just recently granted, and that has to do with gun rights. Okay, the Second Amendment. Okay, and this involves New York. It actually had gone up to the court and back down again. Now here it is again. This one has to do with a question left open or were not reached in the gun cases that the court decided over a decade ago. Okay, and when the court, in a close decision, interpreted the Second Amendment to protect a private right to have a gun, the context of that was a right to have a handgun in your home for self-defense without a trigger lock. Okay, and so the question that gun rights advocates have wanted the court to answer is, what about outside the home? Okay, and so they've been bringing a lot of cases challenging various restrictions about carrying a gun outside the home. And so this is a challenge to a decision here by New York saying that in order to get an unrestricted license to carry a concealed firearm outside the home, a person has to show proper cause, meaning a special need for self-protection. Okay, and a couple of guys were denied permits under this standard, and they brought the case. And so the court has said it'll decide whether, but it looks like it's only going to decide whether these guys were entitled to their permit. Okay, so, you know, again, it could be a narrow case as opposed to a very broad one. A broad decision would say that the Second Amendment requires states to allow people to carry handguns outside the home in certain circumstances. Okay, so we'll see if they go broad. Not clear that they will. But the other thing to note about this case, again, the difference between 5 and 6. Okay, the court, there's a reason likely that the court didn't take gun petitions for a long time. And again, who knows? Nobody can read people's minds, but the speculation is, number one, Justice Kennedy wasn't particularly interested in it. And then number two, maybe Justice Roberts wasn't, Chief Justice Roberts. And so there were 10 petitions pending last year, and the court kept holding them over, you know, wouldn't say yes, no, yes, no. And then finally at the end of the term, it dismissed all 10 of them. So we're not gonna take any of those. Okay, and then we get a new justice, and 4 justices now say, you know, let's take this case. So who knows, but some of us reading the tea leaves might say that those 4 justices believe that the new 5th justice may be inclined to expand the gun right, and we'll see. Next thing, abortion, okay. There's been a petition pending for a whole year in front of the Supreme Court having to do with a restriction on abortion. This one limits almost all abortions after 15 weeks, unless you have to protect the life or health of the mother. Okay, other petitions are pending as well with various different other restrictions. And so the question is, what is the court going to do about this petition or about abortion generally? Okay, and so the question that everybody's talking about is, will the court overrule Roe versus Wade? Will it not? And that really is what we're looking at here. That is it seems clear that the court's going to restrict access to abortion. Even without the new justice, that was going to happen. And the question is, will it do it slowly, you know, incrementally by saying, oh, this restriction's okay, this restriction's okay, or will it just overrule Roe versus Wade? And I just want to be clear that we all understand what it would mean to overrule Roe versus Wade. It wouldn't mean that abortion suddenly becomes illegal across the United States. It would mean states could choose to make abortion illegal unless it was necessary to protect the life or health of the mother. Okay, so in California, the law wouldn't change likely, but in other states it would change. And once again, you know, who would experience that change most? It would be the women in those states who have the greatest difficulty, either paying for abortion or otherwise traveling to get one. I don't necessarily have a prediction of which ways this is going to go, but I am going to say that the addition of the additional justice, I think, makes it more likely that the court will just flat out overrule Roe versus Wade. It seemed like Chief Justice Roberts might be hesitant to do that. Okay, abortion is what a lot of people would call a super precedent, in the sense that there was this big drum roll in 1992 with that case that the court took, where people thought the court was going to overrule Roe versus Wade. And then at the last minute, Three of the justices appointed by Republican presidents who thought they'd overrule Roe versus Wade came together, wrote a joint opinion, and said, we're not going to do it. Okay, so overruling Roe versus Wade would come after that thoughtful, consideration decades ago. It still might happen, but it might make it less likely that it will. Affirmative action, that's a petition that's pending. That's the Harvard Law School, or Harvard College case, where a public interest group on behalf of some students brought the lawsuit against Harvard, saying that Harvard was discriminating in its admissions against students of Asian descent. Okay, the district court said no, they weren't. Said no, they weren't, and said that it's okay under the Constitution for Harvard to consider race to the extent that it does. Now, again, as a plus factor, certainly not as a quota. And the Court of Appeals said that too. And so the petition is now pending before the Supreme Court. And I should make clear that this is Harvard, which is a private university. So the Constitution doesn't directly apply to it, but a statute does. And the court has said the statute, Title VI, has the same standards as the Constitution. So this is viewed as queuing up for the justices, the question about whether affirmative action in higher education can be constitutional. Okay, and several years ago, Justice Kennedy joined an opinion with the more liberal justices having to do with the University of Texas, reaffirming that yes, sometimes, not very often, but sometimes it can be. All right, and then with our new composition, what will it do with affirmative action? I predict it'll take the case and say no more affirmative action in higher education. Okay, the question that the court will look at is whether having a diverse student body, meaning lots of different ideas there coming from lots of different backgrounds, whether that's important enough interest to justify classifying people according to race. And the justices, even before the last edition had said no, they don't think it is. So it seems likely that that's a place where we will see change in the law, but not until they decide to take the case. So not till next year. Finally, just a couple of cases that are interesting, but the court may not take them. One of them is a challenge to the male-only draft. That's been a long time coming, right? But the Department of Defense has come in and said, don't decide it. We're taking care of it ourselves. Women are being able to do all sorts of different things in combat. And so it's possible that the court will decide also, just let's see if maybe, the elected branch will take care of it. Texas versus California, it's another Texas versus California. This is where Texas has sued California because California says that state employees can't travel to states like Texas that allow, and this is foster care and adoption agencies, to discriminate against gay couples and not, let them take placements. Okay, and so California says we're not going to fund our travel. Texas says you're discriminating against us on the basis of religious belief, right? And so it's queuing up the same question that the court is deciding in the City of Philadelphia case, but in a different context because California is spending its money. So likely, I would expect the court won't take it. It may, ask the lower court to reconsider the case once it decides the City of Philadelphia case. Okay, and finally, there's a public union case. All right, we already have a decision that public unions, it violates free speech rights to take money. For a state to say that employees must pay money to public unions, even though they're not members, but for the collective bargaining activities, can't do that. And this is a challenge to exclusive representation by public unions, saying that it's not just the payment that's a problem, it's actually having a law that says that the union is the only representative of all the employees and making a claim that the employees who opt out of the union are allowed to represent themselves. Okay, we'll see if the court decides to take that one. So that's the end of what I've got to present to you, but I look forward to answering any questions that you might have.
Thank you very much, Professor appreciate your time, and we do have a variety of questions which I would like to share from you. The first one, perhaps one of the more sensitive ones, is what do you think about court packing? Good, bad, or your thoughts on it, please?
Okay, well, court packing, let's make sure we all know what it is, because it's kind of a loaded word. Court packing comes from the plan by Franklin Roosevelt back during the New Deal. He was faced with what some might say is a similar type of situation here, but he had a very, very conservative court. We haven't had it going quite on yet, but that conservative court was striking down all the New Deal legislation that was passed by the Democratic Congress and that he was supporting. And so he made the threat that, or he tried to get Congress to pass a law that would add more justices to the Supreme Court. His idea being that that would change the balance and was appropriate because just a few human beings shouldn't be striking down these laws. It turned out that Congress didn't pass the law and that the justices changed of their own accord. They either changed their minds or retired and other justices replaced them. So we didn't have it happen. But that's what's been talked about now, is having Congress pass a law that would add more justices to the Supreme Court. And so what do I think about that? I do think it's a perfectly legal thing to do. It's happened throughout the last 200 years of the Constitution, that Congress has changed the size of the Supreme Court. I think it's unlikely that it will happen. We don't see the president supporting it. He has a commission who's studying what to do. We'll see what comes of that. And it's really super hard to pass laws, as we know, and especially ones that are controversial like this. So I don't think it's going to happen. And that's what I think.
Thank you. Another question. This one I think is a little bit easier, perhaps. As many of us may know, there are sometimes a justice passes away, retires. Justice may also have to recuse him or herself due to conflicts. If there are only 7 justices hearing a case, does it take 4 or 5 for a majority opinion to be issued?
Oh, good question, but I think it's 4.
Okay.
Yeah, but what can happen sometimes is that if you only have 8 justices and they vote 4-4, then what happens is that the court affirms the lower court judgment, the Court of Appeals judgment. And what it's called is the court affirms the judgment by an equally divided court. And that actually happened with respect to the union dues case that I was just talking about at the end of my talk, which is that initially came up challenging California's law, which said that public employees had to pay dues for collective bargaining activity. And that was at the time when there were only 8 justices on the Supreme Court because, the Senate was not confirming the president's appointee. And so that law, the decision, the lower court had said that's okay, the California law. And so that got affirmed by an equally divided court. Then another case came up raising the same issue from another state. And that's when the court took the petition, and then it had 9 justices, and then it said free speech violation.
So you just mentioned the situation that many of us are familiar with when then President Obama nominated then Chief Judge Merrick Garland to the bench, which we all know the outcome of that. One of the participants asked the question, can there be a law, it may also be, what is the likelihood of a law requiring both the president and the Senate to act with consistency when there is a vacancy on the court, et cetera, et cetera? I'm sure you can figure out where the question is going. What are your thoughts on that?
Well, the way that would have to come about is it would pass through the lawmaking process. So just to be clear, the House would have to pass it by a majority, the Senate would have to pass it by a majority, and the president would have to sign it, not veto it. And the question would be, can a law limit what the Senate and the president do? And let's just talk about just for a moment about the holding of the Garland nomination. there are lots of things that are spelled out in the Constitution about how how justices get on the court. Number one, the president appoints them, and number two, the Senate confirms them. That's a political process. The framers knew it, right? And also, we know neither one of those bodies is majority elected, right? But that's just how it is. It's in the Constitution. But then, as far as the timing, exactly of having the advice and consent that the Senate's required to give. What the Constitution does say is that the Senate shall make its own rules of procedure. Okay, so the Senate has the power to make its rules of procedure. But as to the timing of hearing a nomination, whether you have hearings and a confirmation during election year or whether you don't, there's no rule about that. There was nothing written down, and you're absolutely correct about that. And your person who's asking the question is correct too. So that was just simply a decision by the person who controlled the Senate to do it that way. So you're saying, could by law, if you were able to pass it, could you impose consistency on that? And I think it would be up to the Supreme Court to decide whether the full body of Congress could tell one body, the Senate, and the president and another branch, how they're supposed to do their business. And they'd have to interpret those words of the Constitution. The Senate can make the rules of its own procedure.
Interesting.
Notice it would be making a rule of procedure for the Senate.
So at the intro, we heard that you were a clerk to one of the justices, so you have a good insight on the next question. How important is oral argument before the Supreme Court, or are the cases really decided more on the briefs submitted?
I don't think oral argument changes minds much at all. And I served as a district court clerk. And so even at the district court level, oral argument didn't change my judge's mind much at all. I wrote briefs for him beforehand. We talked about it beforehand, and he read the briefs carefully and had an idea about where to go. And so I think that, and the same thing's true of the Supreme Court, which is the justices come prepared to the oral argument. They've thought about a lot about it, and they have their inclinations, right? So often what's going on at oral argument is either they're arguing to each other, because amazingly, they really don't get together and talk about cases, at least not across the aisle. They go to lunch together, but they don't talk about cases. They communicate through these little notes, or at least they did a long time ago. And I have a feeling it hasn't changed. So they're arguing to each other or to the public, or also what they're trying to do is pin one or the other side down, because you'll sometimes see the opinions have quotes from oral argument. Ooh, counsel said this, counsel said that. And so they're trying to get answers that often will help their argument. Now, sometimes they're genuinely trying to get answers and they're wondering about things. I think that goes on too. But as far as really shifting where they're going to go, I think it's less often than not that the justices know where they're going.
I have two questions that are justice specific, as it were. The first one, the person posed the question that allegedly Justice Kavanaugh had significant debts before he was nominated to the Supreme Court, and that such debts were paid by conservative groups. So again, no one's asking you to say whether that's accurate or not, but if it were accurate, would that create any issues as to ethics, recusals, or other matters?
I'm not an expert on ethics rules. And the one thing I will say is that the justices and judges pretty much decide their own ethics. I mean, a long time ago, and it shows my age, but Scalia was going out and hanging out in a duck hunting, one of those little things, whatever it's called, with conservative action people. I think that's what it was. And there was a flurry about should he be recusing himself from the cases that he heard that involved them. And he didn't. So this would have to do with money if it were true. And I just don't know. I'm not aware of ironclad rules about who you can take money from. I mean, I will say these justices fly around to really nice places and give talks. And I think they probably don't take fees for doing it, but they certainly get all their accommodations to advocacy institutes. And both ways. I mean, liberal justices do it and conservative justices do it. So I'm not sure about the debts.
So the next question, in a way, dovetails, no puns intended, what you just previously said about Justice Scalia and the issue with the duck blind. This question relates to
blind, okay. Not a hunter.
That should Justice Comey Barrett recuse herself from hearing cases on abortion, since in the past she has openly supported anti-abortion groups?
Well, again, that's going to be up to her, and I can pretty much guarantee you she's not going to do it.
Okay.
You know, I mean, here's the thing. And again, I always have to offer both sides, right? Which is Ruth Bader Ginsburg. She was the, at the ACLU, Legal Defense Fund. I mean, she brought the cases that changed the law of women's rights under the Constitution. She brought those arguments before the justices and changed the legal meaning. And that's why sex discrimination is prohibited under the Equal Protection Clause when it didn't used to be before. And Thurgood Marshall, again, NAACP Legal Defense Fund, I mean, he brought Brown versus Board, and he brought a bunch of other cases arguing a specific point of view about constitutional meaning. And so it hasn't been viewed as disqualifying to have had those experiences and so obviously aligned yourself with a point of view. The idea has been that when you're on the court, you view yourself as a different person and bound by different standards, not those of an advocate.
There are several more questions, but unfortunately we won't get to all of them. I have one last question for you. Are there any cases still pending before the Supreme Court stemming from the 2020 presidential election?
The election. I don't know the answer to that. I'm sorry, I don't. I think there are cases still pending before the court that have to do with Trump disclosures of materials. But I honestly, I just don't know the answer. I would actually, I'm almost going to say no, because in preparation for this, I read through all the cases that are pending before the court and I didn't see one. So I'm going to rely on that. But I could have forgotten.
Thank you very much, Professor Jacobs. Bob, I'm going to turn it back over to you.
Thank you, Ruth Ann, very much. And thank you very much also, Professor Jacobs, for the wonderful presentation. Let me do this, before I give my closing remarks, a quick message to the attendees to stick with me 2 or 3 minutes here, because I have some information that you may or may not be aware of. But of course, one of the most important pieces of information is that we do appreciate, Professor Jacobs, your participation here today. And the Renaissance Society has made a $25 donation in your name to the Seth Nelson Emergency Grant Fund on behalf of those students in need of financial assistance. Now to the membership, let me do this, sorry, okay. To the membership, today's presentation, as you probably know, was recorded for your convenience and can be accessed by going to the Renaissance Society website or on our forum channel on YouTube. Here's some information, though, that you might not be aware of. Some important items coming up that you'll need to know about. First, the annual general meeting is scheduled for Monday, May 10th. That's in 2 weeks. The Sac State Student Scholarship and Diversity and Inclusion Award recipients for 2021 will be presented at that time. There will also be an update from the Renaissance Board on what to expect for the fall semester. And you will be invited to keep up with activities via Zoom, and that'll occur then as well. So mark that date. It's an important one, Monday, May 10th. Now, as you know, the Renaissance Society will be electing a new board of directors. 33% of the membership is required to participate with a vote. The May Recorder newsletter sent out this past week provided the slate of candidates And if you haven't already done so, please make sure that you vote. If you can't vote electronically, maybe you don't have email, print ballots are available on request. Now, here's some good news. It's time to get ready for Renaissance in the fall. And here are some important dates to make note of. Registration for membership begins on Tuesday, August 3rd. Registration for individual seminars begins the following week on Monday, August 9th. The virtual orientation and rendezvous are at the end of that week on Friday the 13th. And finally, everything begins at the end of August on the 30th. That's Renaissance seminars and programs. All right, so fortunately we have a very good presentation next Friday for our very final Renaissance program. We have Heather Young and Tom Nesbitt, who will be talking about healthy aging in a digital world, technology-enabled models of healthcare. That's next Friday at this time, the final Renaissance Society Forum. Thank you very much for attending. Have a terrific weekend. We'll see you next week.